There has been a growing concern about citizenship in the US, and people, understandably so, are worried. From interpretations of the 14th Amendment to executive orders to court rulings, it seems to be everywhere these days. I got a great question the other day from a YouTuber. What's the difference between federal constitutional citizenship and federal statutory citizenship? I felt that this was something everyone should know and worth making a video on. And just for my viewers' reference, I have two kids. One has constitutional citizenship while the other has statutory citizenship. And while I'm not trying to say that this happens all the time, it sometimes does, and it's good to know the difference between the two. So, these two categories decide how you become a US citizen, how secure that citizenship is, and who controls it, the Constitution or Congress. One of the two types is not as secure as the other, and yes, it is possible to lose your citizenship. We're going to cover all of that in this video and more. So let's start with the more common of the two, constitutional citizenship. The idea of constitutional citizenship comes straight from the 14th Amendment, or change to the Constitution, which was ratified in 1868, just after the Civil War. Here's the key line. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This single sentence changed everything. Before 1868, there wasn't a clear nationwide definition of citizenship. If you're interested to learn more about why the Constitution didn't mention what a citizen was or how to become one, you can watch my more detailed video on the 14th Amendment here. But the 14th Amendment settled it, forever linking citizenship to birth within U.S. borders or lawful naturalization under U.S. law. If you're born in the United States, meaning within its territory, and you're subject to its laws, you're automatically a U.S. citizen. That's what we call birthright citizenship. And if you go through the process of naturalization, you also become a constitutional citizen, because the Constitution recognizes both born and naturalized people as full citizens. Once that happens, your citizenship is permanent. It cannot be revoked by Congress or any other government body. In fact, the only way to remove your citizenship would be to willingly renounce it. There's a whole convoluted process that must be done, and it's surprisingly expensive. In fact, you can't even do this process on US soil. If you're interested in hearing more about this, let me know in the comments, and I'll make a video on it in the future. Anyways, the Supreme Court reaffirmed that constitutional citizenship cannot be removed by the government in a landmark case called Ephraim versus Rusk, which we'll get into at the end because of a few things. One, it derails comparing the types of citizenships, which is what we're trying to do, and two, it's a super interesting case and worth going over. But now it's time to discuss the other type of citizenship. Constitutional citizenship only covers people born or naturalized in the United States. Now, you may be watching this video as a US citizen, but you were born overseas. Or maybe you were born in a US territory, like Puerto Rico or the US Virgin Islands. Either way, this is where federal statutory citizenship comes in. Now, this kind of citizenship isn't created by the Constitution. It's created by acts of Congress. Laws passed under Congress's power in Article 1, Section 8, Clause 4 of the Constitution, to establish a uniform rule of naturalization. Using this power, Congress has passed the Immigration and Nationality Act, or INA for short, which spells out who can become a citizen outside the constitutional framework. The relevant sections are found in U.S. Code Section 1401, and they describe several ways someone born outside the U.S. can be a citizen at birth. Let's look at a few examples. First, there's a few scenarios for those born abroad. If both parents are U.S. citizens, and at least one of them lived in the U.S. before the child was born abroad, the child is a U.S. citizen at birth. If only one parent is a U.S. citizen, then that parent must have lived in the U.S. for at least 5 years, 2 of which were after the age of 14 before the child was born. And there's one other edge case where if the mother is unmarried and a U.S. citizen, she only needs 1 continuous year of residence in the U.S. in order to give birth abroad to a U.S. citizen. These are all forms of statutory citizenship, granted by Congress, not guaranteed by the Constitution. Now, what about those born in U.S. territories? Once a territory was gained, Congress pretty much wrote laws shortly after granting those born there statutory citizenship. In Puerto Rico, it was the Jones-Shafroth Act of 1917. This declared that all citizens of Puerto Rico are hereby declared and shall be deemed and held to be citizens of the United States. This was actually later reaffirmed and codified in the United States Code Section 1402. They did this in Guam, the U.S. Virgin Islands, and the North Mariana Islands. Every territory except American Samoa. It was basically agreed by Congress and the people of Samoa that they didn't want to be full citizens, and we didn't want to give them full rights of citizenship. It's weird, but not weirder than the plot of the Moana movie itself. Why would the ocean choose a toddler? How does a society completely forget their historical past, even though the boats as evidence are still all over the island? And what was this scene?
Too far! God.
But we're going off the rails a bit here. Let's get back to these two things. While both constitutional and statutory citizens are equally recognized as U.S. citizens, the source of their citizenship and the level of protection it has are very different. Constitutional citizenship is permanent. Statutory citizens have some potential strings attached and can best be described as conditional. Okay, remember when we mentioned that interesting Supreme Court case? Ephraim versus Rusk in 1967 helped make constitutional citizenship permanent and untouchable. Now, Bayes Ephraim was a naturalized American citizen. He'd come from Poland, became a U.S. citizen in 1926, and then later moved to Israel, where in 1951 he voted in an Israeli election. Now, at the time, a federal law, Section 401E of the Nationality Act, said that any U.S. citizen who voted in a foreign election automatically lost their citizenship. And no need for alarm, this law was done away with in 1978 and is no longer active. So if you can, go ahead and vote in another country. But when Ephraim applied for a new U.S. passport, the State Department actually said, sorry, you're no longer an American. Now, Ephraim fought back, arguing that under the 14th Amendment, his citizenship was a constitutional right, and that Congress couldn't just take it away. The Supreme Court agreed, barely. In a 5-4 decision, the court ruled that once you've lawfully obtained U.S. citizenship, whether by birth or by naturalization, the government cannot revoke it without your consent. Justice Hugo Black wrote the majority opinion saying, the 14th Amendment was designed to put citizenship beyond the power of any governmental unit to destroy. This Supreme Court case established a firm ruling. Citizenship is a constitutional status, not a gift that Congress can take back. That is, constitutional citizenship. This story changes when we start to talk about statutory citizenship, the kind that only exists because Congress created it by law. That brings us to Rogers versus Belle, decided in 1971. Aldo Belle was born in Italy to an American mother and an Italian father. Under the law at the time, the Immigration and Nationality Act of 1952, he was a U.S. citizen at birth, even though he was born outside U.S. territory. But Congress had added a condition to keep that citizenship. Belle had to live in the United States for 5 years between the ages of 14 and 28. He didn't. When he applied for a passport, the State Department said, you lost your citizenship because you do not meet the residency requirement. Belle also took this to court arguing, if the 14th Amendment says you can't lose citizenship without your consent, then neither can I. But the Supreme Court disagreed. Because Belle wasn't born or naturalized in the United States, the court said he wasn't a 14th Amendment citizen. He was a statutory citizen, a citizen by the grace of Congress, not by guarantee of the Constitution. The court basically said Congress has the power to decide how and under what conditions citizenship may be acquired by birth abroad. And because Congress creates that citizenship, it can also attach strings to it. So in Belle's case, his citizenship could legally be taken away, not as a punishment, but because the law that granted it required something he didn't do. Now I have to make this perfectly clear. This does not mean Congress can just arbitrarily strip citizenship whenever it wants. Even statutory citizenship has limits. Congress cannot take away citizenship as a punishment, like if you broke the law or went to jail. That would violate due process and other constitutional protections. Congress also cannot apply new restrictions retroactively to people who already met the law's conditions. Here are the things that Congress can do. They can change the requirements for future generations, like how long a parent must live in the U.S. to pass citizenship. I think the last time this changed was the very early 1980s, where parents had to live longer in the United States if they wanted to give a child born abroad citizenship. Congress can also include retention conditions, such as requiring residence in the U.S. for a certain number of years. And if those conditions are not met, Congress does have the power to revoke your citizenship if you fail to meet existing requirements at the time they were granted. That's the key distinction. Constitutional citizenship is automatic and permanent, and statutory citizenship is conditional and legislative. Now, over time, these retention conditions became very controversial. In 1978, Congress repealed most of them, recognizing that it was unfair to make someone prove their Americanness by living in the U.S. for a certain number of years. So today, Congress no longer enforces or writes laws that automatically take away someone's U.S. citizenship once they already have it. But it still defines the rules for who qualifies as a citizen at birth overseas. And if you don't meet those legal requirements, you're simply not recognized as a citizen in the first place. In other words, Congress can't take away your citizenship if you already have it constitutionally, but it can define and limit who qualifies to have it by statute. That's the enduring legacy of Rogers versus Belay. It drew a hard line between citizenship that the Constitution protects and citizenship that Congress creates and controls. This distinction still matters in the modern world. People born in Puerto Rico, Guam, and the U.S. Virgin Islands are U.S. citizens because Congress granted them statutory citizenship. It also matters for children born abroad. Every generation's rules depend on how Congress writes the law at the time. So here's the bottom line. If you're born or naturalized in the U.S., your citizenship is permanent. Congress can't touch it. No worries. If you're born abroad to American parents, your citizenship exists because Congress says so, and Congress can change those rules for the future. Understanding where your citizenship comes from helps you understand just how the Constitution and Congress divide power in defining who is we the people. I also want to give out a huge shout out to my Patreon cabinet members, Howard and Kevin. Thank you so much for your support. If you want to support this channel, becoming a member on my Patreon is the best way to do it. Okay, that's it for now. Thanks so much for sticking to the end of my video. I hope you enjoyed it. I hope you learned something. We'll make more videos soon.